we close the chapter and our tour of the three branches with the most consequential recent development in American law, the work of the Roberts Court under its 6-3 conservative supermajority, and the story has a clear turning point. For the first decade of Roberts' tenure, the court was marked by cautious incrementalism. Roberts often joined the liberal justices in high-profile cases to produce narrow, institutionally protective decisions that avoided the appearance of partisan alignment. But the addition of Amy Coney Barrett in 2020 ended that equilibrium. Roberts was no longer the pivotal swing vote. Since 2021, the court has issued a string of decisions that have fundamentally reshaped constitutional doctrine. Let me walk through the landmarks, because together they tell a story. Dobbs v. Jackson in 2022 is the most consequential. It overruled Roe v. Wade and Casey, holding the Constitution confers no right to abortion and returning the issue to the states. The first time in the modern era, the court withdrew a recognized fundamental right. Bruen, also 2022, transformed Second Amendment doctrine with its historical tradition test for gun regulations. West Virginia v. EPA constrained the administrative state through the major questions doctrine, requiring clear congressional authorization when an agency regulates matters of vast economic and political significance. Students for Fair Admissions in 2023 ended race-conscious college admissions, overruling Rodgir. Loper Bright in 2024 overruled the Chevron doctrine, taking the authority to interpret ambiguous statutes away from expert agencies and returning it to the courts. And Trump v. United States in 2024 recognized broad presidential immunity for official acts. Now step back and see the cumulative effect, because it's a genuine redistribution of power within the constitutional system. Power flowed from administrative agencies toward courts, from Congress toward courts on statutory interpretation, from the executive toward courts on administrative law, and paradoxically from courts toward the presidency on the question of criminal accountability. The judiciary, the least dangerous branch, has substantially expanded its own authority at the expense of the other branches, and that has triggered a genuine legitimacy crisis. The court's legitimacy has been challenged more openly than at any time since the New Deal era, with proposals for term limits, mandatory ethics rules, which the court adopted in limited form in 2023 after disclosures about undisclosed gifts to several justices, and even court packing. As of 2026, none has been enacted, but the debate intensifies. So we end where we began, with Hamilton's paradox. The branch with neither sword nor purse has become, in many ways, the most powerful arbiter of American life. And the question of how a democracy should hold that power accountable is one of the defining constitutional debates of our time. Thank you. That completes our study of the three branches.